Hello, my name is Ken Schwartz. I'm an attorney in New York with an office in Bethpage, and we are a boutique firm that specializes in distressed properties, real estate where there's a foreclosure or something else is not going the way you'd like to see it go. We handle litigation, short sales, loan modification agreements. Anyway, this discussion is about loan modification agreements. Now, a loan modification agreement is what someone will apply for when they want to retain a property, when they want to keep the property. The first thing you need to know about a loan modification agreement is it's important to ask the question whether you want to retain the property. And what I mean is this: if you have a property where the value is worth, say, $250,000 and the outstanding debt is $500,000, that means a negative equity of $250,000. Now, you certainly have the right to apply for a modification agreement and perhaps keep the property. But the big question is, what are you keeping? You're keeping something with negative equity. The likelihood of positive equity could be years away, and you have to carefully evaluate the opportunity that you may have to acquire another property with a mortgage that does not exceed the market value. Economically, it could mean disaster by keeping a property like that. But on the other hand, if the value of the property is roughly equivalent to whatever the mortgage comes out to, or whatever the secured debts come out to, then it could make sense to do a loan modification agreement. Now, getting approved for a loan modification agreement, yes, it means an application to the loan servicer, not necessarily the investor, and the loan servicer being the agent for the investor. Every loan servicer has different requirements in terms of an application and how the procedures go, but the common denominator is there is an application, and you need to show that you earn income. Now, when you fall behind on a mortgage and you look to do, say, a short sale, you plead poverty and you show that you're not earning any income. And those are all the reasons why a lender would approve of a short sale. On a loan modification agreement, it's quite the opposite. You want to show that you do earn a satisfactory level of income so that the servicer can look to you and say, yes, this is a borrower who is qualified. And the financial ratios need to work out. Roughly speaking, the lender will be looking, or I should say the loan servicer will be looking at two types of financial ratios. One being the ratio of the payments under the mortgage, inclusive of taxes and insurance, to monthly gross income. And that needs to work out somewhere between low 30s to the low 40s. And then they look to the back-end ratio, and the back-end ratio would be your overall debts, and the ratio of overall debts to your overall monthly gross income. If the financial ratios are not working out, they will turn you down for a modification agreement. You do have an opportunity to bring in other folks and use their income. If they're a member of the household, or if you can demonstrate this is someone that would normally contribute to the payments of the mortgage, even though they are not technically a borrower, you can factor them in to your application and perhaps qualify in that sense. Now, there are laws now which were put into effect in the early part of 2014 by a brand new federal agency called the Consumer Financial Protection Bureau, CFPB for short. The CFPB has very wide authority, very roving authority to issue regulations that govern loan modification agreements, which is one form of loss mitigation. And by the way, the CFPB has a very extensive website. If you patch into it, you can see that the CFPB has jurisdiction over loan modification agreements, loss mitigation, collection agencies, and credit repair, and any number of other areas that were previously governed by other agencies like the FTC. Anyway, Under the regulations that were issued by the CFPB back in January, they went into effect in January of 2014, loan servicers are required to respond within a given number of days after an application is submitted, and the deadlines are very tight. It also provides something that's very useful for consumers in general, mortgagors in general, that if a foreclosure is pending, particularly in a sense where a foreclosure is pending and a foreclosure sale is coming down the pike in the near future, the regulations, and this is under Title 12, which would qualify it as a HUD regulation. Specifically, the site is 12 CFR, which is the Code of Federal Regulations, 1024.41 for those who look at sites. Anyway, these regulations prohibit, in Subdivision G, they prohibit something called dual tracking. Dual tracking means that a servicer can't proceed to sell a property at the courthouse steps or to obtain a judgment in foreclosure and at the same time entertain an application for loss mitigation. There are deadlines. If at least 37 days remain prior to a foreclosure sale, a mortgagor has the right to make application for a loan modification agreement, and the dual tracking provision would go into effect. And that dual tracking provision under Subdivision G would say that as long as that application is pending, and pending could mean that an appeal had been taken under the regulations, the servicer cannot move forward and sell the property at the courthouse steps. Is this a right without a remedy? Can you go to court and make them stop doing it? I don't know. That law has yet to develop in this area. Some folks say yes, some folks say no. We're very short on legal authority in terms of decisions coming down in that sense. But if you are inclined to retain your property, a loan modification is the way to do it. And what you need to know is, yes, showing income, substantiating income is a very big part of the process. You can get approved within, say, 45 to 60 days if it's handled properly. If you're not showing sufficient income, then by all means consider bringing somebody else into the application process that can make you qualify. And if you do qualify, you get to keep your house. This is Ken Schwartz once again, and I'll see you in the next part. Have a great day. Bye-bye.